Hi, Assalamualaikum warahmatullahi wabarakatuh. My name is Tasnim ASRI and my partner, ALIYA ZAHAR AFFENDI. So today we are going to present our assignment, which is a fact of incorporation. There are two questions prepared, and which is question number 2. And this is for company law subject, which is HLC 2013. Okay, so the story goes by Hadi owns a house which was later sold to Hijau Berhad, a private company. So he is the sole shareholder and also director of Hijau Berhad. Before the sale was made, Hadi had insured the house in his own name. The house was later destroyed by floods. So as the owner, Hijau Berhad had tried to make an insurance claim but failed as the house was not insured in Hijau Berhad's name. So can Hadi make an insurance claim because he is the holder of the policy? State your opinion based on the doctrine of separate legal entity. So the issue here is Hadi can or not make an insurance claim for the house that was destroyed by a flood. So, in my opinion, Hadi has no right to make the claim even though he is the owner of the insurance policy. Why? So, to support my opinion, when the company incorporate one of the effect in this matter, Hadi and Hijau Berhad are two different things. And Section 18 of Company Act stated 5 things, which is the first, there must be accompanied by the name and registration number as stated in the principal register kept by the registrar for this purpose upon the date of incorporation mentioned in the notice of registration, which is issued under Section 15. And second, every person whose name is stated as a member in the application of incorporation and on the company's incorporation shall be entered as a member in the register of member alongside with any other person who may become the member of the company at any time is a body corporated by the name stated in the notice registration. Number 3, in the case of corporation with a share capital, every person whose name appeared on the application becomes a stakeholder in the firm. The fourth is the company registered office address is as mentioned or in connection with the registration application. And the last one is the person listed as a director or secretary in the statement, if any, is presumed to have been appointed to such position. And because cases are related, the Lee versus Lee's Air Farming Ltd case can be used as example for Hadi case. So Geoffrey Lee, Catherine Lee's husband, founded the company with the help of Christchurch accountants who work in Canterbury, New Zealand. So their company do top dressing, which is the process of applying fertilizer to farm from the air. So Mr. Lee owned 2,999 out of 3,000 shares and was also a director for the company. He had complete control over the company's affair and made all the company's contract decisions. The company engaged into numerous contracts with the insurance agency for employees' insurance, and a few premiums for personal policy taken out by Lee in its own name were paid through the company's bank account, but it was debited in Lee's account in company's book. And in addition of being a company director at the same time, Lee was a pilot. During an aviation top dressing mission in March 1956, Lee was killed while operating the plane. Lee's wife, who is the appellant, filed a claim for workers' compensation under the New Zealand Workers' Compensation Act 1922, alleging that Lee was injured while working for the company. The New Zealand Court of Appeal dismissed the appellant's claim because it refused to recognize Lee as a worker, stating that a man cannot effectively employ himself because Lee was the company's owner and possessed the majority shares. The respondent company claimed that his wife was not eligible to employees insurance because he had been not a worker. So Mr. Lee cannot be the company's owner according to the respondent because there is no master server relationship between him and the company. So Mrs. Lee claim is valid according to privy counsel because Mr. Lee can have a contract with the firm he owns because it is separate legal entity. But in terms of UK Company Law and Indian Company Act, this judgment is significant because it creates the principle that a business is a separate legal entity that can form relationship in a business matter with its own employees because they are both legally distinct. And for your information, Salmon versus Salmon Co. Ltd was the first case to create the concept of separate legal entity. And separate legal entity is like a two-edged sword in that it can be exploited in bad faith by interested parties to hide the corporate veil that it offers between the firm and the member. So I would like to pass the presentation to the next presenter.
Thank you, Tasnim. Okay, Assalamualaikum warahmatullahi wabarakatuh. My name is ALIYA of ZAHAR AFFENDI, and I will continue with this presentation. Okay, there are also other cases of Guildford Motor Co. versus Horn, where the court pierced the corporate veil and considered the respondent and his firm as one thing to ensure the legitimacy of the contract that appellant had with respondent. The idea of a separate legal entity was rejected by the court. So in addition, the notion of a separate legal entity does not apply in the event of insolvency, and the company and its members are treated as one thing. Separate legal entity, for my opinion, is an important aspect of firms because it serves as a separate company's identity with its members, but it also be utilized for fraud. Despite the fact that our legislature has created and implemented numerous rules and regulations, our judicial system is cautious in protecting stakeholder interests. So the company can also have its own property as a result of incorporation. In Macara versus Northern Assurance Co. Ltd, this case also can be an evidence for this case, for Hadi's case. So Mr. Macara, the appellant in Macara versus Northern Assurance Co. Ltd, 1925, held various timber plantations in Ireland. He sold them to a corporation in exchange for practically all of the company's stock. Mr. Macara then insured the lumber in his own name with the defendant firm. The timber was later destroyed by a fire on the estate. So Mr. Macara filed a claim against the policies, but the defendant denied the appellant's claim, claiming that the timber was no longer his to insure because it had been purchased by the corporation. The appeal was denied by the House of Lords, which ruled that the appellant had no right to the items. So the timber was the company's property and no longer belonged to him. It didn't matter that the appellant was the company's primary creditor and beneficial shareholder. In any case, the fire-damaged timber was not his property. Thus, he was unable to file a claim under the insurance policy. So as an application, the house is owned by Hijau Berhad, while the insurance policy is owned by Hadi. So the capital that owned by the company, Hadi cannot make any claim on it. For the conclusion, Hadi has no right to make any insurance claim due to the house bound by Hijau Berhad. When Hadi sold the house to Hijau Berhad, so Hadi doesn't have any insurance interest on the house anymore. So that's all from us. Thank you.